So another twist emerged in the trial of the founder of the indigenous people of Biafra, Nnamdi Kanu, as he informed the court that there was no valid charge against him, therefore that it was needless for him to enter a defense in the matter. Recall that Honorable Justice Kayode Omotosho of the Federal High Court Abuja had given Nnamdi Kanu 6 days to commence his defense. The court had earlier adjourned the matter to 23rd October 2025 after proceedings could not continue when Kanu's team of lawyers withdrew from the case. However, when the matter came up today, 27th October 2025, Nnamdi Kanu again failed to commence his defense for the third consecutive day. In court, Kanu elected not to enter a defense, arguing that there was no charge known to law before the Honorable Court. Justice James Omotosho directed Kanu to put his argument in writing and serve the prosecution accordingly. The case was adjourned to 4th, 5th, and 6th of November 2025 for final addresses. Before adjourning the matter, however, the court took time to admonish Nnamdi Kanu to seek the guidance of a competent criminal law expert regarding the risks associated with the decision he was about to make. So a lot of people have been speaking and asking what are the implications of Nnamdi Kanu's decision not to enter a defense in the matter. Number one is the right to fair hearing. No one can argue that Nnamdi Kanu has not been given the opportunity to present his case in defense against the prosecution's case. If anything goes wrong, the court's record will clearly show that he voluntarily waived his right to present evidence to counter the charges. Under the law, a party who has been given full opportunity to be heard cannot later claim denial of fair hearing. Number two is the risk of relying solely on jurisdictional objection. By refusing to enter a defense, Nnamdi Kanu is effectively resting his entire case on his argument against the court jurisdiction and on the evidence already presented by the prosecution. Even the most experienced lawyers rarely place all their eggs in one basket when challenging jurisdiction. When a party relies solely on preliminary objection on the basis of jurisdiction, they risk having their entire case succeed or fail or crumble on whether the prosecution has sufficiently proved its case. They risk having their entire case fail or succeed whether the other party proved this case and also on the strength of the objection alone and nothing more. The third implication is that Nnamdi Kanu has chosen not to challenge or disprove the evidence adduced by the witnesses of the prosecution. In law, where evidence adduced by one party is left unchallenged, it is deemed as admitted by the other party who refused to challenge such evidence. This could be very fatal as the defense will have no evidential foundation to contest the case either before the trial court or on appeal. In this instant case, perhaps the major highlight of the day's proceedings was the caution from Justice Kayode Omotosho, who advised Nnamdi Kanu to seek counsel of an expert in criminal litigation regarding the course of action he has chosen to take. Please comment and follow our page, and if you are watching us from YouTube, please do subscribe to this channel and drop a comment. That will help us a lot.